All right. It looks like we are live, coming to you from all the different coasts and nooks and crannies of the US. And we will one day come up with a name for the three of us doing this. Maybe you guys can come up with a name for us doing this. We just text each other and we're like, should we go live? Yeah, let's do it. And that's about it. So here we are.
Earlier today, someone put in one of my comments, legal Mount Rushmore. Which I'm kind of
I feel like we need a fourth to be a Mount Rushmore.
I know.
Yeah.
Dog,
I do like Law Avengers. That I liked that one. Somebody put that one in one of my comments. It was great.
I like that one.
Okay, so the three amigas. I like that. I saw that.
I like that.
A lot to cover today. So much so that I don't think we've even had a chance to digest all of it. But because people have been reading, we want to try and help as much as we can understand what the filings are. So this is really intended to recap as much of the filings from yesterday as possible in the Lively Wayfarer case. And there were a ton. Namely, there was additional dispositive motions filed, which we can go into those. But the and those might be the star of the show, frankly. But the pre-trial stuff is what needed to be filed yesterday. And so the pre-trial stuff was all the motions in limine, which is parties' attempts to exclude the other side's evidence, and for some reason, and we can go through those in some level of detail. And each side has filed a ton of them because there's a ton of evidence that they don't want coming into trial because they don't want a jury to see it. So there's that. There's the pretrial statement that the parties filed, which they had to file jointly, and there's obviously some objections on each side of those. There's voir dire questions. This is questions that go to the jurors, potential jurors. There's proposed jury instructions for what the judge will say to the jury and what they will tell the jury on how to decide on all these issues. So a lot has been filed. So I'm going to kick it to you guys. Where do you think we should start?
I feel like the motion for summary judgment and judgment on the pleadings is the most technically thick. And with you guys here together, I think that's a really good way to parse through that, to really talk about that. The judgment on the pleadings I'm in love with, and you guys know I've been secretly like, okay, what's the argument against this? Like, what are the holes to poke here? So I'd love to chat through that with you guys first, if that's where you're good with starting.
Yeah. Oh, I see a little Frank butt in the back.
Oh yeah, he just went to sit by the bathtub because he has to watch 24 hours. Okay. I got a bunch of questions today. I'm sure you did too, LGA, that I thought maybe we could answer. It's the same question, which is it usual for a judge to like hint, you ought to make this argument? Because I did see some people say like, that seems kind of unfair. Like, you know, if the lawyers can't come up with the arguments. And my response was, tell me if you agree, was in a simple case where it's like, hey, you know, you can move to dismiss, a judge wouldn't do that. But because this case is so complicated and they had page limits and he knew they had to cut arguments, I think he was like, I know you're aware of this and I'm just telling you, like, don't forget it. But I didn't see it. Like, judges won't do that if you're like, if you just miss a huge thing because you're dumb and bad at your job, they're not going to be like, hey. But to me, it was more like this was so full of stuff and there were like 50 arguments made. And I just wanted to recognize that this one got dropped.
I also wondered if their agreement to keep the motions under, what was it, 60 pages? If the judge was like, there are additional arguments here. So now that we've laid out what's available and what's left, there are a few arguments based on the case law that as a matter of law you can make. So do you want to make those again? I'm going to open the door for you. I wondered if the 60-page limit fed into that a little bit.
I think it has to, because there were so many claims here that they tried to move on in a limited space. There was the fight over the page limit was limiting both sides, and both sides didn't end up filing motions for summary judgment, which I thought was a little sneaky to say, we're both going to agree to a page limit and then not file, which is annoying. And so I think overarchingly, the judge is most concerned about appeal. And the judge does not want to get appealed. Judges just generally don't want to get appealed. And so, especially in a case of this high profile, so much attention and likelihood of appeal, there's a reason why this was a 152-page order. It's not typical to get a 152-page order on a motion for summary judgment. I've never received a 152-page order on a federal single plaintiff motion for summary judgment that I've litigated. So I think that tells me that the judge is particularly concerned about appeal. And because the judge is particularly concerned about appeal, is making sure that everything is resolved on the merits before this ends. And so by maybe indicating softly that this is something that wasn't addressed that should be addressed, to me, it's not for sure that that's what he was doing. But if that's how the parties interpret it, and then they come up with a motion for judgment on the pleadings, which they are entitled to do before trial, then that's the positive result for the court, because now those issues will be resolved on the merits.
Yeah. Yeah. And realistically, you don't want something going to a jury that, as a matter of law, shouldn't be brought anyway, right? I mean, you want to be really clean about what you're putting in front of a jury, because juries are messy. So you want to clean up the mess, tidy everything up so you have a tight case to bring to a jury.
Yeah, and people have pointed out that jurors are, and sorry, I didn't mean to cut you off, but jurors are not as, this is not to be demeaning, but jurors are not as sophisticated in understanding the nuances that everyone following this case, including the parties, have been acutely aware of leading up to that point. And so they're very susceptible to being confused by something if they don't have all the context, whereas they can have all the context. And so the easier that the case can become for the jury, the better it is for the court, honestly.
Yeah.
Well, and also, I think people saw in the motion for judgment on the pleadings and the motion for summary judgment, a lot of what you have to do in a case this big and complicated is alternative arguments. So it's like, well, I think you should throw this out, but if you don't, then this. And if you don't do that, then this. But if those two of those three happen, then this. And they weren't able to make every single contingency argument, right? And so the argument that they made last night was the argument to make only if their other arguments about FEHA didn't work, right? So it was like, well, FEHA is still left. And so now you can make arguments just about FEHA. And so to me, it's when a case is straightforward and there's only one or two claims, that's a totally different thing. But when there are practically infinite arguments to be made, I think that, like you guys said, the judge doesn't want to show up on day one and be like, hey, by the way, I've realized that we can't do this. Right? Like nobody wants it to happen. Yeah.
Yeah. A question I saw a lot was whether they're allowed to bring this. I think they are. I think that, of course, the court has discretion to say, you should have brought this earlier,
right,
and you didn't. But under 12C, which is the rule under which you bring a motion for judgment on the pleadings, I don't think it prohibits you from bringing a legal argument before trial if you have it. So, I mean, I think it boils, and I'd have to go read all the case law on this to know for sure, but I think it boils down to, is the court going to exercise this discretion to entertain this argument ultimately? Yeah. And it's a purely legal argument, and it goes directly to reducing the issues for trial, which is exactly what a MJOP is designed to do. So I don't see any reason why he wouldn't entertain it when it makes his life and everybody's life easier, if it can be decided as a matter of law.
Especially if it seemed to me what Wayfarer was intimating was, what if we go through what if you say no, and then we go through this whole trial, and then we file a post-trial motion, which can happen, where you say like, hey, the jury actually shouldn't have decided this because the law doesn't allow it. And then you have to undo a whole jury verdict. Like that doesn't make a lot of sense. So why shouldn't we just deal with it now? To your point, for efficiency, I'm sure that Blake's response will include in it right up front, they shouldn't be doing this now. But technically, you can file a motion to dismiss or a motion for judgment on the pleadings all the way until the very first day of trial, technically.
Mm-hmm. Yeah. Yeah. And I mean, it was a very exacting, specific motion. It was getting to the heart of what is a retaliation claim on the law. And so it's hard to kind of dismiss as being irrelevant or not helpful at this point, because at the end of the day, you want to bring claims that are ripe for a jury. And this motion says it's not. And here is why, basically.
Yeah. Yeah. You know, I think it's worth the shot too, right? Because the worst case scenario is the judge says no, and now you're still trying retaliation at trial. But it also is something that's appealable. And keep in mind, with a lot of issues, if you do not make them, they get waived, right? So you want to have this on the record somewhere so that when whoever loses appeals this, because best believe this is not over. If Drake can appeal, so can Blake. So
BRB, I'm going to go get my microphone. Okay. I'll be back. Talk amongst yourselves. I'll be back.
Yeah. So I guess what we could do is give a quick recap of what that argument was in case people missed any of the recaps on it. But essentially what Wayfarer did was file a motion for judgment on the pleadings, a motion to dismiss, same standard basically, that says, sorry, Britt, I think we can hear you typing.
sorry.
It essentially says
I was told I have to change the name of our stream because no one knows what MIL means. And they were like, mother-in-law. And I was like, okay, fine.
That's fair. Maybe some people have the same feelings about the MILs as mother-in-law. So the motion was basically suggesting that, and it's kind of a complicated thing to explain, but the logic is that Lively didn't have a reasonable basis for bringing her or making a protected activity or conducting a protected activity, however you want to say it, because the conduct that she was believing to be illegal was never under FIHA. It happened outside of California, and so it was never conduct that FIHA was regulating. And because it wasn't conduct that FIHA was regulating, she didn't have a reasonable basis to make any complaint about it. And because of that, she can't have a retaliation claim because there's no alleged illegal activity that she was opposing. That's kind of in a nutshell what they're saying. And the logic is pretty sound, I would say.
Hang on one second. LGA, tell your waiting room to come here because 1,000+ people waiting for you to start it on your page.
Waiting room. How do I do that? Why are they waiting over there?
I don't know.
Guys, I'm not technically savvy enough.
I relayed the message. I am out here saying MIL chat and I'm getting yelled at about that. So
okay, you guys talk. I'm gonna take a look.
Lauren's like, what are you guys doing? Look,
Lauren. Not all of us are YouTube real YouTubers like you. Okay, some of us are just lawyers.
That's it. Yeah.
Okay, we're not that great at everything.
Lauren, people were telling me about this lunatic that called you. I need to know all about that. Do y'all know this? That some woman from the producers guild
the voicemail.
Oh my gosh.
It's like a minute and a half long, maybe longer. It's crazy.
People are crazy.
My favorite is you weren't there. And Lauren's like, you weren't either? Like,
what? Right. Thank you, Lauren. My God. And of Lauren of all people, right? Like the nicest person who tries so hard to be, objective about it. Like people are kooks.
I think almost called her back and said, why don't you try me next time?
Yeah.
I got some things to say.
I think Blake's response to the MJOP is going to be, but the damages had to emanate from California because Abel and Nathan and Baldoni and Heath were all in California. And I understand that argument.
Yeah.
I do. But I think that Wayfarer's attorney, I think Bach and Shapiro did a really good job of articulating, like, yeah, by that rationale, any protected activity that occurs anywhere in the whole country could be subject to a retaliation claim under FEHA as long as some of the adverse stuff happened in California. And that doesn't seem right.
And then that gets into the question of if there's different standards for protected activity, and you guys could probably answer this better than me, but if we have a different standard for protected activity in New Jersey, and that isn't covered by the protected activity in California, is that enough, right? I don't know. I think that gets into really complicated legal questions that we don't need to be bringing to juries.
No, because if she wanted to bring her claims under New Jersey law, she would have done that. She didn't.
Mm-hmm.
And they made a choice to bring it under California law. They could have brought it under New Jersey law, and they didn't. And it's now far too late, and they cannot do it because there's a statute of limitations. So whatever that decision was, we can speculate, but whatever that decision was, they made that decision. And so it's game over for New Jersey. It's now you either win in under California law or you don't, and the judge is saying you don't. Yeah. So it's some people have talked about it as if it's like a gamble. It's not really a gamble; it was a choice. And maybe you could say it was a gamble in the sense that they decided to do one over the other for whatever reason, but it was a choice that they made, and they could have actually brought it under both if they really wanted to cover all their bases, and they chose not to do that as well.
Yeah.
Clark asked the question that I knew somebody would ask, which is Wayfarer has put that Instagram post that keeps getting community notes on it on their evidence list. And yeah, I would do it too if I were them, because she keeps changing her story. Right? Like, wouldn't you love to cross-examine her on that? And then also something she said 3 months ago, and then also something she said in a deposition, and then also what she said in the complaint. Like, it's just one more opportunity to be like, the story keeps changing.
I thought that was funny. Like, why?
Go ahead.
Sorry, go ahead. No, go ahead, Britt.
And then in closing, you get to really drill home. Can you see why we hired Crisis PR? Because she's a moving target. We had no idea what was coming next. You've seen here today. Her story changed several times over the course of this case. That's what it was like to work with her. And we had no choice but to protect ourselves because we just couldn't predict what she was going to do next. That sets you up for a great
and they could use that community note. And I have to be honest, I don't totally know how the community notes work because I'm not as deeply entrenched in Instagram as I used to be. So I don't exactly know where that comes from, how it's formulated, if it's one person that drafts it or what. But it's, first of all, it's a party statement. She said it, and it relates to her claims, and it would go to show the organic response that people have to her if they're talking about, whether or not they're manufactured all of these things. It's interesting to me that they would want to exclude something that she created that is getting some kind of backlash. Like, I just can't see how it would be excluded. But I think the most ridiculous one is that they're trying to preclude the testimony of Shasti Flaw.
Come on.
I thought that was the most ridiculous one because they literally alleged that she was part of the smear campaign. And I have to go back and look at the exact second amended complaint language, but I think they went so far as to suggest that she was being paid by Wayfarer to make the video, or that she was doing it at their behest in some way. And now they're saying, no, we're just going to prove that Tag amplified it somehow, or they pushed that video out more somehow. And that's the only thing. So we don't need to hear from her because that's all that we're saying. We're saying that Tag amplified it. And maybe that's a fair argument, but I just find it sort of like, whoa, we're doing a 180 here on this one.
Yeah. I mean, to say there was a smear campaign about me, you're not allowed to see what it was, but just trust and believe. And we don't want you to hear from their expert. We want to take their expert out of the equation, which is normal. I mean, I'm not trying to make it seem like that's abnormal, but let's take out our expert. And I only want the jury to look at that text message where they say, we can bury anyone. And that's it. That's the testimony. And that's how we're going to prove smear campaign. It's like, well, that's not enough.
Exactly. I mean, I was looking through it earlier today and I was reading, I admittedly haven't read the Daubert motions in as much depth as I've read the other motions in limine, but it appears that the lively position is the experts can't give opinions on how all this worked because that's not sound science, but we also can't allow any lay opinions, including articles that were written on this, because that's not appropriate opinion. So it's like, so what is? Like, if you can't have experts to explain it, and you can't have the stuff that we all saw to explain it, then how do you explain it? Right. It backs them into a corner where it's like, what evidence are they supposed to use? And it reminds me very much of that point that Lyman made in the order, which is Lively can't prove retaliation simply by discrediting things that the Wayfarer parties say. She has to affirmatively show her own evidence.
Right.
And it's like, what evidence is that going to be? Because you seem to think that experts can't do it and lay people can't do it and articles aren't good enough and social media posts don't work. Like you said, is it just going to be that one email from a year and a half ago?
I think so. The Daubert motion really drove home for me that her best evidence that there was a smear campaign was the "we can bury anyone" text. We are still at square one with "we can bury anyone." And for me, that is not enough. They take issue with Wayfarer's, what did we say her name was? Alexandra Nicole?
Nicole Alexander. Close enough.
You told me 3 minutes ago. Nicole Alexander, it's bad. Nicole Alexander, their online smear campaign expert, worked at Meta, has a background in this, right? They take issue with the fact that she takes a data set larger than what they're claiming is the smear campaign, to which I'm like, we want that. We want to see if there's organic conversation that looks like this over here before the smear campaign began, to see if they look the same. Because if they look largely the same, if the negative conversation before retaliation happened is the same as what it looks like over here, we need the jury to know that. What does online discourse that's negative about Blake Lively look like?
Well, and I made a quick video about this earlier today because I was getting myself all wrapped up. How do you prove what is organic and what is not without calling every single person who made a frickin' comment, right? Yeah. Like, the experts are supposed to be able to give like, this generally is how this works, but the expert can't make ultimate conclusions. So yeah, it does seem, you're right, Britt, like she's trying for there to be like the only case that Wayfarer can really make, or the case that she makes is, well, they said they were doing it, so they probably were.
Right. Yeah. But also didn't, and you guys correct me if I'm wrong, in my memory, the campaign to smear her in the documents that are their bid for here's the menu of services we offer was way more than what they actually ended up paying. So we can infer that based on what they were paid, they didn't choose smear campaign tier level subscription. Correct me if I'm wrong on that. That's how I remember things going.
Yeah, and that's a kind of a big part, I would assume, of their defense, is that when you go into, In-N-Out's not a good example because there's like literally 3 things on the menu, but like you go to Cheesecake Factory, there's like 250,000 things on that menu. Just because it's there doesn't mean that you're going to buy it.
Right.
So it was offered to them, but Lively has to prove that that's what they paid for. That's what they wanted, and that's what they ended up doing, and then prove that they did actually do the things that were on the menu. And I think, to go back to this about the experts, I mean, to be fair, Wayfarer also moved to exclude all of Lively's witnesses. So each side is saying your experts are crap.
Yeah.
So no experts should be in this case. And in a funny sense, they're all kind of right.
Yeah.
Because none of the experts can really actually tell us whether or not it was organic for people to dislike Blake around the time of the premiere of the movie or not. Because to your point, Nag, how can you know without asking every single person that made a video or a comment around that time how they came to that conclusion or not? You can only make a guess, and there's no expert on the earth that can prove that. And so in a sense, it's like none of the experts should testify in this case. I mean,
Right.
don't hold me to that. People are going to be pissed, but I like, it kind of makes me think that
if the judge kicks an expert, he's going to kick both. And if the judge keeps an expert, he's going to keep both. He's not going to kneecap somebody and say, you get an expert and you don't. And I think, you know, you can handle it at voir dire at trial if they start to testify way off the rails about stuff they don't. Because Blake's expert, Aaron Perez, actually did a really good post on Reddit about this. Blake's expert makes a lot of conclusory statements with no data sets to back it up.
Right.
And if that's the case, what you do is you say, Your Honor, I'd like the chance to get some testimony, voir dire, which means the jury leaves, and now we are questioning this expert to see if they're allowed to continue with their expert testimony, right? So, and then you try to kick that and you move to strike, and it's a whole big show, and the jury's like, ooh, what's going on? And, you know, they come back, the expert's gone, ideally, if you did your job right. It's a whole fun game. God, I love trial.
Well, like, this is what, first of all, I see Cheesecake Factory slander in the comments, and I will not stand for that. They have some good things at Cheesecake Factory. I stand by it. But this is the whole thing. Like, I think, LGA, you and I have been saying this since the beginning. This is why this stuff isn't an adverse employment action. Because when there's an adverse employment action, there's parameters around what did this do to your employment? How did this hurt your employment? When it's defamation, like a Johnny Depp situation, it's like that was false. False things hurt your reputation. Right. But like, I think the reason that everybody's lost is because it doesn't make any sense. It's like, how do you just make a presumption that all online content is organic unless someone can prove otherwise? If I was the Wayfarer team, I think that's what I'd be arguing is I think we have to assume that everything we see is real until someone can prove to us that it's not real.
And they
because
need
if we're
more
going to have
than
this
just
standard,
a
we have to
text
prove
message.
everything is real. Yeah.
Right. They need to show us bots. They need to show us a way of falsely inflating engagement. They need to show us a way of manipulating the algorithm. And without being able to do that, we can't just take them on their word that one text message offering a menu of services that our invoices don't say we took. That's not enough. That doesn't meet her burden.
So I think it might be helpful for folks to know what kind of buckets of evidence the parties are trying to exclude.
Yeah.
And we can go into the ones that seem most interesting. So I'll just recap. So Lively's trying to exclude any evidence, and this is what I think is really funny, that refutes Wayfarer's organic backlash theory. So they want to exclude anything like the gossip articles about Lively's past, her mean girl behavior. They cited to 3 specific examples, which I wasn't even aware of these. A 2009 article where she used the word tranny. An article from 2020 referencing the plantation wedding, a 2014 article about slavery that relates to slavery. These are damaging for Blake Lively's reputation. And they're saying we should not allow any of that before the jury, because what Wayfarer is going to do is say that the backlash that Lively had was organic, and they're going to point to these previous things to prove it's organic. Well, duh.
Yeah.
I mean, I'm sorry, but duh, like that is the literal argument that they have, and they're trying to clip them of this defense that they cannot offer essentially any evidence that people were talking about things that they disliked about her outside of the movie, outside of what is tied to Wayfarer in any way. And I think that one's going to get denied. Any thoughts on that one?
Yeah, I mean, I wish they had done all of the TikToks discussing those very things, because my algorithm had every single one of those coming up, right? Discussions of the preserve clothing line and the antebellum wedding and all of it. But yeah, I just don't know how you say, oh, you don't get a defense.
Yeah, essentially that's what it is.
Because-
You don't get a defense.
And again, this is the smear campaign. This is the conversation that was going on online, but don't look at it, but just trust me, there was one.
Mm-hmm.
Oh,
I think it's fair to say, like, you know, we need to make sure the jury understands that we're not saying that any of these things are 100% true. We're saying these are the things that were out. This is a reputation case, and these things were out there about her.
Yeah.
It's not as if she had a stellar reputation, and all of a sudden one day she didn't. But like, if you look in the footnote on this section, it's like there's 2 footnotes on 1 page, and I highlighted because this is literally what it says. This motion in limine is intended to address the exhibits and others that defendants may seek to introduce, to prohibit defendants from mentioning, discussing, implying, questioning, or alluding in front of the jury anything about Miss Lively's character, reputation, or similar concepts based on old gossip articles and statements. Girl, this is a reputation case. That's their whole case.
right.
Like, I think Lyman is going to say, you put your reputation in issue, and maybe there are limits, outer limits.
Sure.
Like, you know, the stuff about, like, I think it's proper to say, like, maybe Shiersty can't say everybody hated her because she doesn't know that.
Yeah.
Right. You can authenticate her video and she can say, I can tell you what the activity was on my account when I posted that video, but she can't make a general. I agree with that. Like, she can't say, oh, well, the internet, like, that's not appropriate. But to argue that she can't say anything at all when she's in the business of, you know, dealing with celebrity reputation, yeah.
And claiming harm to reputation. Like, if you're putting your reputation on trial and you're saying the defendants harmed my reputation, then your reputation preceding what you're accusing the defendants of harming is at issue. And in order to prove that your reputation has been harmed, you have to show that you had a good reputation to begin with. And they should be able to show that you didn't have the best reputation to begin with. So I can't see how... I mean, there might be specific articles or specific pieces of evidence that might just be too far outside to qualify as that organic backlash theory or whatever they're calling it. But generally speaking, I think you've put your reputation on trial. And
I do think, though, if this stuff is coming in, he's not going to say then she can't have people testify to her good character, right? If we're going to talk about her bad character, she needs to be able to refute that with testimony of her good character. So when I was reading that portion of Wayfarer's motion in limine, I was like, I don't know. I think it cuts both ways. It's okay, let her do it, and she kicks down the door if she does. And then you get to bring in all this stuff where it's like, actually, she had a really bad reputation, and here's stuff going way back to 2009. So I don't know that either of those get granted.
Yeah, and we should take one more step back, I think, because we didn't really talk about how these motions in limine are born. Essentially, each side sits down with their client and with themselves and think, what are the possible pieces of evidence? What are the possible things that could come up during trial? And what do we not want in trial? And makes a whole big list of those things. They see what the other side has listed in their pretrial order as possible exhibits and what they're going to use them for, and look to see if there's any legal grounds to exclude that evidence from coming into trial, and then create these motions in limine. A lot of them, in my experience, is throwing spaghetti at the wall to see what they can get out.
Yeah.
There are Hail Marys last minute Hail Marys to get as much stuff that you don't want in the trial out as possible. They know they're not going to win on all of these. Nobody assumes that they're going to win on all of these. And that's why there's always a ton of them. In fact, I thought there might be more. I'm surprised that it was under 20 for each side. But that's just to give context to people that like that's what these are. That it's very, very typical for parties to have a laundry list of things that they don't think should come in.
Yeah. I just want to answer a question that's come up a couple of times in the comments, which is, yes, everybody gets to respond to everybody else's motions. Like in a case, there's no such thing as a motion that gets granted or denied without somebody responding to it. So they all have until next Friday to respond to each other's motions. I don't know that they get replies. I think it's just motion and response. But yeah, it seems to me that there's like a difference between this is what people thought she did, whether that's true or not, right? People thought she was racist because she got married on a plantation. It doesn't really matter whether she's racist or not, but that's what some people thought, right? Because the whole thing is about what did people think of her, and was Wayfarer able to make that to like fundamentally change what people thought?
Right.
And to me, there's just a distinct, like I just looked at the motion again. And she says, we think that Wayfarer is going to try to say that some of these gossip articles are true. And to your point, LGA, like maybe they will and maybe they won't. It's just, I think she's just kind of bringing it up to be like, just so you know, we don't like this.
Yeah.
Yeah. The switcheroo that happened is that Lively's trying to exclude Van Zandt, which everyone was curious about.
Yeah.
Which I was not expecting that, but I can understand why. And they give us a little bit of like background for it. And I think it actually just is not a good look for them moving on this, because they're like, well, you know, nobody moved to quash that subpoena, and then documents went over to the other side. And we don't want to talk about it because
John and Jane Doe didn't appear to quash. Whoa, crazy.
So they don't want Van Zandt to be mentioned because they know it's charged, very, very charged. And potentially they don't want a jury that may have heard of it. Oh no, we lost Neg. I think.
And then there were two. Going back really quick to motions in limine. It is my experience that judges, most of the time, unless it's extremely prejudicial, to the point where it would so prejudice the jury's mind that they couldn't come up with the right opinion, you know, that it would so sway them that it would change the outcome of the trial to the detriment of justice being done. That isn't the exact language, but most of the time a judge will say, deal with it at trial. See how it comes in at trial. So you would re-raise all of these objections in trial. And that's how judges normally handle motions in limine, in my experience, 9 times out of 10.
Yeah, I was going to mention that in my experience as well. A lot of these motions don't get decided before trial. They get handled at trial as needed. Yeah. So if something comes up, they'll have a sidebar with the judge or go into the chambers and fight it out with the judge behind the jury or without the jury's presence and deal with it as it comes up. Because some of these things might not come up at trial, or as they go along, they realize it's not even relevant. They're not even going to call that witness. It's not even an issue, or it really becomes an issue. And the court wants to see just how much of an issue it really become once it's actually presented to a jury or about to be presented to a jury. So we might not get a ruling on all of these. He might rule on some of them, but I don't think we'll get a ruling on all of them before the trial.
No. And then if you don't make it at trial,
rules on the yes. Right.
Sorry, Nag, we missed what you said. If he rules on what?
No, I'm having internet problems, and I don't know why, because I have as many bars as I can get, and it's still not doing right.
This was me or last
if he rules on the motion for some reason.
Go ahead.
Yeah, it's my internet and my house sucks. If he rules on the
No. Turn your video off and try audio. Or reduce your resolution on your camera.
She's working on it.
Got
We'll
it.
give her a chance to work on it. You're moving now. You're here now.
Okay. Well, y'all are frozen for me. It's me. Okay. Okay, there you're back. Okay, let's see how that goes. Jesus.
It might help to turn off video and we have just your audio. It might help for a bit.
Yeah, if I need to do that, I will. Okay, I'm going to go play with it. But anyway, I was just going to say, if he grants the either of the dispositive, I realized this morning, I'm sure this is going to be like a duh to you guys, but if he grants the MJOP, tags MSJ doesn't even matter.
Yeah.
Because if there's no FIHA retaliation, there's no retaliation to aid and abet. So, that one motion could basically take it to one.
That's deadly for her case. The other thing too is that if he keeps the retaliation but gets rid of tag, I don't know how they get in the "we can bury anyone" text.
I don't either. They're going to bring Stephanie Jones in there and say she's the custodian of the records?
Right. But it's still hearsay. I mean, I guess to prove they acted based on that promise, right? So this promise was made to them and to prove they acted in conformity with that text message, but that's not effect on the listener. Like, I don't really know how we get that in through the exceptions of hearsay. It's a tough call.
There's no way to argue they're not offering that for its truth.
Oh,
right.
100%.
Like, you're offering it to show that they said they could, but like,
exactly.
I don't know. And then I started thinking, and then like, even if, let's say they drug Jones in there to try to find some exception that it's a business record or whatever, but it's not, because she wasn't, Jones has argued that she wasn't working on behalf of Jones Works when she was talking to Melissa Nathan. Like, she said she did this behind my back.
Mm-hmm.
Yeah.
So it can't be a business record either. I agree. I don't know how they get that thing in.
Yeah.
Now,
I don't think they can.
Interesting thought about what about the New York Times article? So they can take judicial notice of the article, but what about the stuff in it?
Well, it's not being offered for the truth of what's in it, right? It's being offered as, well, who would offer it? First of all, would it be the Wayfarer side showing?
Because Blake is offering it for the truth.
Yeah.
Oh, is she? I didn't see that.
I would. Well, no, that's the argument you make. She's absolutely. This is an article that she had commissioned. This is hearsay. And Megan Twohey's not testifying, and she's the one who wrote it. And a custodian from the New York Times isn't introducing it. I don't know how we get it in. I
don't think it comes in for that purpose.
And Wayfarer would be stupid to bring it in.
No, I don't think
terrible.
I mean, I can't even imagine what the retaliation would look like without those emails, because we all saw them before we saw anything else.
Mm-hmm.
Right? But like, if those are out, what is there? I mean, then they have to rely on those spoliation sanctions, which I don't think they're going to get.
I don't either.
No.
I mean, my main reason for thinking they're not going to get them is because when Little Girl and Attorney and I were there, the judge just let this guy argue for like a half an hour. He didn't ask a single question. He didn't give a shit.
He didn't give a shit.
He was like, sure. If he was going to do that, he would have asked questions about how do signal messages work and how are they sorted. He was just like, okay, great. And then he just let the guy leave.
Yeah.
So I don't think she's getting those.
If Tag is out and Say Jones is in, and if Van Zandt is still in, then does that open the door also for New York Times?
No.
No. And that's what we're saying. If Tag is out, Jones can testify to whatever she wants to, but it's still hearsay, right? She can't introduce. So when you introduce evidence at trial, you generally have to have someone who can authenticate the document, meaning that they were the creator of, or can, there's a whole business record predicate that I won't get into, but it was drilled into, I'm sure it was drilled into you, Nag, as at your school, right? Or, at work. But
Mhm.
there are certain ways you authenticate documents to come into trial. So it can't just be anybody ever, oh, I know about this, so I can bring it in. You have to have somebody who is a part of creating it, or who was the maker of it, or who sent the text, who created the photograph, or, was a recipient of the photograph.
Yeah, you've got to lay a foundation for it, which means you've got to have somebody with the capacity to say this is real.
Yeah.
And then if it's hearsay, which all documents are, you have to find some exception to hearsay. And like, I remember fighting with this one person. I can't remember who it was. One of the people I ended up having to block. Maybe it was that person with the cat avatar. Anyway, what was that person's name? Do you remember early on? And they were super pro Blake. And anyway.
Noodle?
Noodle. That was it. That was it. And I just remember fighting with this person, and they were like, but these things are all evidence. They're attached to the complaint. And I was like, you don't know what you don't know, which is a bunch of personal text messages are really hard to get into evidence because they're all hearsay.
And technically, it is my practice that you don't attach stuff like that to a complaint because it's improper at the complaint stage. You attach a contract, maybe some additional writings if you're trying to say there's some sort of extrinsic evidence to show parties' intent around the contract, but you attach very limited things to a contract. And the fact that they did doesn't make it evidence.
No.
Just makes it allegations.
I mean, that's a good point. And I think we've been using the term evidence throughout this case as kind of in a little bit of a loose sense. But really nothing is evidence until it gets admitted into court as evidence.
Yeah.
Like everything is just discovery. There's just stuff. You can discover stuff all day long. You can allege stuff all day long. None of it is evidence until the court enters that thing into evidence formally at trial. And so anyone
exhibit blah blah blah.
Exhibit is now entered into evidence as exhibit. Yeah, that's it. That is the moment when something becomes evidence. And so all of these exhibit lists, yes, they're called exhibit lists, but they're hopefuls. They're hoping to become exhibits in the case. And there's a strict scrutiny by which each piece of proposed evidence becomes evidence in a case. There's a whole freaking class on it in law school. There's a whole class about what becomes evidence, and it's really hard and really annoying. And that final was on my birthday, and I resent it. But but yeah, it's not just like, oh, it's here, therefore it becomes evidence. You have to authenticate it. You have to make sure it doesn't violate all of you violate the hearsay rules and have an exception for it. All of these things have to happen before the thing that you think is going to be evidence becomes evidence. And so even when they were saying Lively's side has 1,000 pages of evidence, it's like, actually, does she? Because how much of that actually gets in? And that's kind of to give people a context for what we're kind of chatting about. We're chatting about, can any of this stuff actually get into evidence? And given what we know about hearsay, and given what we know about the laws around evidence and rules of evidence in federal court, we don't think a lot of it can get into evidence because it's going to fail at all of those steps that it has to take to get to evidence.
Right. But it's partially the combination of people not being parties anymore and also living outside the trial subpoena jurisdiction of the court, right? So it's Nathan and Abel and Baldoni and Heath as individuals not being parties, because admission of a party opponent is how you can get stuff in usually, because that's a hearsay exception. But also the fact that they all live in California and the case was filed in New York, the court can't require them to be there. And that is a deadly combination for her. Now, all the stuff that Blake said, the PGA letter and the Instagram post, she will be there.
She said it.
Dismissing all of the individual defendants, except for the couple that are left, is deadly for her case. Because now we are talking about the sexy comments are no longer party opponent admissions. So they are Like, they're not excluded by the hearsay rule, right? So
The text between the defendants.
the text between the defendants, statements by Jamie in her trailer, right? Like, all of that is gone. And now you have to find some sort of hearsay exception to weasel it into, to be like, we're not offering this for the truth. We're offering it because it was an excited utterance. It was a, present sense impression, right? And the other side comes back and goes, they're absolutely offering this for the truth. They want the jury to think that this person said that and they meant it.
Right.
Mm-hmm. Yeah.
And if they come voluntarily, a couple of people have asked, if someone were to come voluntarily, they can still limit what they can testify about if they're smart about it, because the only thing that Lively's people will be able to do is cross-examine them. They won't be able to have them be a direct, because they can't subpoena them. And cross-examination is limited to the scope of the direct. So if Wayfarer were to bring Jen Abel or Melissa Nathan and ask them a very defined set of questions, then all that Lively can ask her in its cross is what comes out of those questions. So as long as they don't open the door too broadly, even if they're there, the Lively people can only ask them the way that the Wayfarer people frame it. I mean, it really is a problem for them. A big one. What do you guys think about Ryan Reynolds showing up on the witness list out of nowhere?
I was surprised by that. I'm surprised by that, and I'm not at the same time. Like, obviously he's gonna want to talk, but I'm just thinking through what the implications of that are. He did not get deposed, and supposedly because of privilege, because of spousal privilege. So pray tell, what exactly is he going to testify about when the other side did not have the opportunity to depose him? Like, I can't understand how that could be permitted at all.
I can't either.
I think it's hilarious that he was not deposed. He didn't show up to mediation. He's been MIA. He's made no social media posts, which, could have been a directive by their lawyer. Fine enough.
Not a party.
Although if the lawyers did say don't be posting about this on social media, Blake sure didn't follow that directive. Right? And now
neither did her lawyer. So
now all of a sudden Ryan Reynolds is like, I'm here for my wife. And I'm like, where you been, bud? Like,
they're going to, they say that, I'm just pulling up the pretrial order. They're listing Ryan Reynolds to testify about regarding defendants' misconduct related to the film, post-production of the film's promotion and marketing campaigns, defendants' retaliation and aiding and abetting, and Miss Lively's damages suffered therefrom. He can't testify about any of that.
Also, a lot of that is hearsay.
Yeah.
The marketing he can speak to.
Marketing,
the comments, maybe we can talk about some comments to WME, but everything, he was on set for what, one day? So he can speak to what he saw on that one day. But he doesn't get to say, my wife came home and told me X.
Yeah.
One, because
spousal privilege,
right?
Yeah.
But also she's got garden variety emotional distress. So we don't get to hear any of that.
They were saying she was sexy and they were being sarcastic, and okay, that's all hearsay. That's barred by the hearsay rules. So,
I think if he got up there to talk about the marketing, that would be a huge gift to Wayfarer, because then they would be able to cross him on, so all of this terrible marketing that was part of the reputational problem for your wife was you?
Yeah.
Like, why would they put him out there for that? I think that's it.
And they're simultaneously trying to preclude any conversation about Nice Pool and the marketing of the Deadpool Wolverine movie. So you want him to come and testify about the marketing of a movie that he wasn't part of, but you're not going to allow any testimony or questioning of him about any sort of digital or whatever, what are they calling it? Digital violence or what have you with respect to Nice Pool and any statements that he made. So yeah, that's wild to me.
I could see him throwing Sony under the bus for marketing. It's a lie, but people lie under oath all the damn time. And I could see him saying, this is something we worked up with Sony. This was not solely on us. Sony never told us to stop. We thought it was going really well. I could see him getting up there and saying that.
Well, especially because they've also moved to preclude the internal conversations among Sony.
Mhm.
And so they're hoping to just silence Sony, at the very least, have someone like Ryan come out and testify against Sony, potentially, to your point, Britt.
Yeah.
But a lot of that's hearsay too. Like, right?
Yeah.
I mean,
Yeah.
there's so much of this that, like, I'm sure Wayfarer is not going to tell Sanford Panich or whoever the head of Sony that he has to show up. But, you know, I don't think that if their plan is Ryan will give everybody like the star factor or some shit, maybe that would work if they were in like middle America. But I just don't think that
New
people
York
from New York
cares.
City are
Yeah.
going to give a rat's fuck. I really don't.
Yeah.
I mean, that's why celebrities live in New York, because they're like, yeah, nobody cares.
Yeah.
You're
You can
right.
walk
Like,
down the street. Yeah.
yeah, I just don't think that they're gonna. I don't know. I think it would be a gift to them if he put himself up there.
Yeah.
Yeah, agreed.
Yeah. I was really surprised to see him showing up at all, but you know.
I'm sure the response from Wayfarer in some of these will be, you mean the guy who wouldn't let us depose him? That guy?
Yeah. Cool.
Maybe it's a backhanded trick by them to be like, okay, well, he's agreed to be deposed now, so I guess we have to push the trial back. I mean, who knows?
Yeah.
Yeah, it seems like a bad move to delay the trial. I don't know why either side would want to delay the trial at this point, but
I have depositions next month, so if they do delay the trial, like, thanks, guys.
Can I focus on one because I was so excited to see it because I had said it like a year ago?
Yeah.
Yes.
That is the argument, and I don't think they got it from me. I think it's just, this is an argument we would all make, which is that the contract rider agreement is to some degree a subsequent remedial measure.
Oh,
Mhm.
yeah. Yeah, yeah.
Right? Like, I was so excited when I was reading, I was like, that's what I said.
Yeah.
Mhm.
Because, you know, it's almost like, how do you, I mean, they tried to like split the hairs. For those of you who don't know, there's an evidentiary rule that says you cannot use subsequent remedial measures as a way to prove liability. In other words, if someone sues because something is broken, you cannot use evidence that they fixed the broken thing to show that it was broken in the first place.
Or
And
that they
just-
broke it.
And just so
Right.
we're all clear, these rules all have reason for them. And the reason for this one is we do not want to discourage people from fixing their problems. We
Yeah.
want people to go in and go, yes, we made a mistake. We're going to fix it. But that means you don't get to use it at trial that they did wrong.
Right, exactly. It's like if you have a pothole and your car gets messed up and then they fix it, we want them to fix the pothole, right? And I think they're right that rider agreement is to some degree a subsequent remedial measure because they were trying to fix whatever it was that was wrong.
Yeah.
And if they cannot utilize the context of that document, as that document was intended to fix the problems on set, then the definition of retaliation makes even less sense.
Yeah.
Right?
And it did fix it because she alleged that there were no problems on set after.
Yeah.
So, you know, I think it actually cuts both ways for them. Like having it in, having it out. I mean, the fact that they signed it, the fact that they agreed to it, and the fact that there's an allegation or admission by the party that there was no harm done after that, it actually harms Lively.
I would love to read her whole deposition anyway, but I would love to know how she answered because I know they asked her, and according to your allegations, there were no problems second round of filming. I would love to know what she said, because I could actually see her at her deposition going, actually, there were tons of problems. I don't know why my lawyer said that, because it's not under oath, right? It's not a verified complaint. So I could see her coming in and being like, and then there was this, and then there was this, and then, you know, at the premiere, and there were issues during promotion of the movie. So I could actually see her coming up with a lot during her deposition. So who knows what she's testified to, but her allegation, to your point, is there were no other problems.
Well, I did see, I don't know if you guys got a chance to look at, there was one thing, it was put on the docket as Wayfarer's jury instructions, but it's actually their verdict form. And if you look at the rider, because this is a question a lot of people have been asking, in their verdict form, which is literally the form that the jury goes back and checks, you know, yes or no, did they prove this, yes or no? Wayfarer has, hold on. Did Blake Lively and It Ends With Us Movie LLC enter into a contract? Yes or no, right? So they have to prove that there was a contract. Did Blake Lively use a wrongful act or a wrongful threat to pressure It Ends With Us Movie into consenting to the contract? Was It Ends With Us Movie so afraid or intimidated by the wrongful act or wrongful threat that it did not have free will to refuse to consent to the contract?
Which is a video I made very early on.
Very early. Would It Ends With Us Movie LLC have consented to the contract without the threat? So they are very much going to argue threats, duress, all of that. Mm-hmm. Yeah.
Yeah, that's a question that keeps coming up. Is that a question of law or fact? And at this point, it is a question of fact for the jury to decide the facts that lead to that conclusion.
And I don't think that's I think that is a question of fact. I don't think you bring that for motion for summary judgment. So we had this discussion in somebody's comment section. I don't remember if they argued it at summary judgment, but that's not the kind of thing you want to bring for summary judgment, because it's so easy for the other side to go, we don't decide that here. Look at all these questions and facts they're trying to put before you, judge. They're ridiculous. Kick all their arguments out.
Yeah. What's going to be interesting on that one is we have never seen, like, the communications were happening primarily between the lawyers, right? So it was Lindsay Strasberg and then Emin, I think, who worked for Wayfarer, but they can't testify because that stuff is privileged, right? So Heath can testify that on behalf of It Ends With Us Movie LLC, he felt intimidated, he felt duress. But who's going to argue or who's going to testify on the Lively side that someone didn't? Because we've never even heard Blake in her own words, unless she waives the privilege for Lindsay to get up there. I don't know. I don't understand what evidence they would use for that.
Yeah, me neither.
Blake told Jenny Slate that after break, something like it was a whole new set. She fixed everything. Yeah. Yeah, I think if she testified to something differently during her deposition, by the way, it was made up somewhere along the way, just so we're clear. Maybe not made up, but over exaggerated as to, you know, they looked at me sarcastically one day or something like that.
Oh, something that comes up a lot and maybe we can help with is the distinction between the contract dispute and the retaliation claim, because the word retaliation appears in both of those, but they mean very different things.
Yeah.
And maybe I'm not explaining this well, or maybe I'm explaining it incorrectly. So I'm going to call on you guys to help me. But the contract uses the word retaliation, but it is not the same as legal retaliation. They're using the word retaliation in a vernacular sense, kind of like when you say,
being harassed.
I'm being harassed, when that has a legal definition that meets a certain number of elements that you have to constitute harassment, but it actually doesn't mean the same thing in vernacular. And so here, what they've done in that contract writer agreement is they've used the word retaliation and defined it as a list of things like sarcasm and negative attitude and essentially like being isolated or whatever. So they've defined retaliation in a particular way, and the claim, the contract claim, is going to be looking at whether that provision that defines retaliation pursuant to how they've defined it was violated.
Yeah.
Right? Did that, which I think is nuanced and can be very difficult to distinguish from the fact that there's a legal retaliation claim that has elements that have to be met in order for it to constitute retaliation. So, I mean, I don't know if you guys, what do you guys think about that? But I've been seeing a lot of questions about that.
Yeah, I mean, basically, you can enter into a contract, and as long as it's not prohibited by law or something that would be void by law, you can make these definitions. So you can't make a contract to say, I always think of like premarital contracts, right? Or like probate stuff. You know, my daughter can't marry an Arab man, or she never gets my inheritance. That would be void by law, right? But you, within the realm of what's allowable, you can say we're prohibiting retaliation between these parties, and this is how we're defining retaliation, not under the law, under the rules of this contract. And so we're still going to throw it through the analysis of, is there a contract? Was there consideration? You know, did the parties perform? Was it breached? Is that, you know, did that breach cause damages? So you're still going to run it through the contract analysis, because we're not talking about legal retaliation. We're talking about a contract term. And that term could have been anything. No sarcasm allowed. Sarcasm is defined as.
Sarcasm.
I have to go back. Look, like, does it go both ways, or does it just go one way?
One way. I think it's an unenforceable provision because it's vague. It doesn't say who decides. It only goes against one party. I think it's unenforceable personally. I don't know that they're going to get that far into the weeds, but
I agree.
Yeah, which begs the question of why the judge kept that claim.
Well, maybe he's waiting for, I mean, if it's a breach of contract claim and they, let's just say they decide there's a contract and they decide that they violated because someone was sarcastic one day, what damages could that possibly be?
Yeah.
I mean, first of all, contract damages are totally different than tort damages, right?
Right.
But also Wayfarer had the motions in limine that were the most, not surprising, but to me seemed the biggest deal, are the ones where they try to throw out the entirety of her reputational damages, right?
Mm-hmm.
And I don't think, to Britt's point, it's very hard to be like, how much damage can a sarcastic comment cause you? Right? So
When it's not public.
Right. Where do we go from there? It looks like from the jury instructions that Wayfarer is counting on the fact that a juror is not even going to find that there's a valid contract in the first place because they were forced to sign it.
It's just crazy to think if hey, Justin, how are you? Well, apparently my 2-year-old doesn't think pooping in the toilet is appropriate anymore. Is that sarcasm under the contract? Like, you know what I mean? Like, it's just so wildly overbroad and unenforceable, in my opinion. But I agree with you. I think given the totality of the circumstances around entering into that contract, the being screamed at for hours and all that, I just don't know that a jury is going to be like, yeah, that's enforceable.
Well, and they had a movie to finish. You know, they signed the agreement because they're like, we need to finish this movie.
We are losing money every day that we are not on set.
Yeah. And like, whether or not the consideration was enough or not, you know, that was the judge's call on that. But like, at the end of the day, they signed it because they're like, can we get on with our life and finish this movie? And how can, what evidence are they going to provide to suggest that they violated that contract unless they're trying to say that the hiring of a PR firm violated the contract writer agreement somehow. But I don't know how they can connect those things.
And it muddies the water too, because it's like, we're not talking about legal retaliation. We're talking about retaliation under this contract. And it doesn't say you can't hire PR if you feel that your reputation or the movie or the studio is being threatened, right? That's not in there.
Yeah.
I'll be right back.
Yeah, I'm just looking at it again. And this part has always bothered me too. And this is just not very well drafted, but sorry, Lindsay. There shall be no retaliation of any kind for raising concerns about the conduct of law. And then we have the changes in attitude, sarcasm, yada, yada, yada. And then it says, these are all the things, whatever, is retaliatory and unacceptable and will be met with immediate action. So it doesn't say you're responsible for damages that arise out of retaliation. It says, if you do this, we will take action, which nobody did. Nobody said, we're going to enforce this contract. Remember, you're not allowed to do that. So I think there might be a halfway decent legal argument that doesn't even entitle her to damages. It doesn't give her a private right of action because that's not what it says.
Well, did you see Wayfarer had a motion in limine about anticipatory protected activity?
Yeah.
So they said that Lively is going to say that she alleges that Wayfarer took retaliatory action in anticipation of engaging in a protected activity, which is they're rewriting
the world.
That's not how it works. You don't retaliate for something that's going to happen in the future. You retaliate for something that's happened in the past.
Yeah.
So you can't retaliate to something. You can't preemptively retaliate. That's not retaliation. It literally beguiles the definition.
That's true. There is one motion of Blake's that I do agree with, and that is keeping the nice pool stuff out. I know that people think that that's great. I just don't think it's as good as people think. I don't think it's helpful.
It doesn't speak to the issues.
It doesn't.
I think there's a little bit of artistic expression in there. If Ryan genuinely believed his wife was being harassed or threatened, yeah, maybe he based nice pool on Baldoni. But to go through and be like, here's what an Easter egg is, and there's this flower shop, and he's got a man bun, and I don't know.
Well, here's what I think. I think if Wayfarer comes back and says, this is what we were up against in the summer of 2024. This is the landscape that we were operating in. We saw a major motion picture, Marvel, come out with a character that was essentially making fun of the director of the movie that we're about to put out. And there are links that they can show that people pieced that together. And that if they can present that evidence to show towards their motive for hiring Crisis PR, then I think it's relevant because they're going to have to be able to paint the picture of why they went and sought Crisis PR, and everything that happened around that time in the PR world is directly relevant to why they ended up hiring Crisis PR. That's what I would argue.
You sold me.
That's a good argument. Yeah, you sold me.
Guys, too easy.
You sold me. I feel like Ryan's comments to WME, which again is hearsay, so it's tough to get in, but from Wayfarer's perspective, that's not hearsay. Your Honor, we absolutely are not introducing this for the truth of the matter asserted, because we're not trying to prove that Baldoni is a harasser. We're trying to prove that this was the impact on us as people who eventually heard that this is why we were fired, right? Mm-hmm. And we reacted with Crisis PR because of that. So I think those can come in, but to your point, LGA, there's a similar, Ryan is out in Hollywood smearing these guys to anyone and everyone that'll listen. And so, yeah, setting up that landscape, I think, is really important.
Yeah, I think everything that happened that led to them to hire Crisis PR they should be putting in as evidence to suggest this was our motive, because retaliation is about motive. What was the motive? Were you substantially motivated by the fact that she refused to take pictures with you at the premiere? Or were you substantially motivated because there's all this other shit out there that's making you look bad and you're trying to like make sure that the dam doesn't break and the water floods?
God, I just feel like her promotional videos alone, right? She's doing this. They're marketing the movie like this. We are begging Sony, please, for the love of God, you know, and you don't even need that communication. You say, we went to Sony and demanded change. You can get that in. They'll object to hearsay, but the jury's already heard it, you know. You testify to that and you say, she's trying to blame this on us. And meanwhile, the internet is now digging to see what else they can find. And here are the other things they found. I don't know. I feel like that alone is going to sway a jury. So setting up the whole landscape is just.
Even if you didn't get into the content, like, this is why I don't know why they would bring Ryan, because you could say, don't tell me what you said, but you contacted the president of Sony about this, right? Mm-hmm. Right. Don't tell me what you said. But you contacted the head of WME about this, right? Like, you have these guys' phone numbers, right? Like, I think if they are just able to position, I think the thing about making Ryan the thing they were afraid of is it's easier to prove because everybody knows who he is, whether you like him or don't like him. Mm-hmm. He has shown how much power he has, because when he sends a message, he sends it to the person at the top. Yeah. Right. Yeah. He goes straight to the top. And also, you don't have to worry about like, oh, would this sweet little blonde woman really do this? Right. You can take that part out of they're making her out to be some sort of villain. No, you can make her whatever you want to be. He's the villain.
Yeah.
That to me seems like a much easier case to make. That, you know, what she could do, she did some things that were obviously problematic, but it was made much, much scarier by the fact that he was standing right there with her.
He's and he's the driver of, I mean, I feel this way anyway, but right, the trial strategy could very well be he's the driver of this. This isn't a he said, she said. This is a he said. And we've got one of the most powerful players in Hollywood making these calls
to our agents,
to
our contacts, to our business partners, to the major studios that we will have business relations with in the future. We are freaking out and we have to protect the studio.
Yeah.
That to me is their substantial motivating reason for hiring crisis PR potentially, than it is to, you know, destroy some actor's name, an actor who played in their movie. Like if I was Wayfarer, I'd be like, why would I want to smear my lead actress in my blockbuster movie? Why would I want any negative attention on her? Because it would then reflect that I chose someone negative to play in this movie. Like that. So the thing about the substantial motivating factor is that they have to really show how big that motivation was, because it's not a but-for causation. So it's a little bit more difficult for them to defend. And so they have to show everything that motivated them to act the way they did. And having someone like what was his name? Ryan Reynolds.
Nice pool.
Already forgot his name. Having someone like Ryan Reynolds who's talking to like Ari Emanuel and the big wigs of this industry is a substantially motivating reason to want to protect your studio, your small, little, somewhat unknown studio.
Yeah. And I don't know how, let's just assume for the sake of argument that Lively is able to get in all of the stuff about burying people and make the inference that Jed was boosting things and whatever. How do you prove that wasn't just a plan to still protect Justin, because she had set it up as it's either you believe him or you believe me?
Right.
So if he is saying negative things about her, that is necessarily saying, you know what I mean? She's the one who set up the zero-sum game of it's me versus him.
Yeah.
So when he is denigrating her, I think there's an argument that he's necessarily protecting himself. I just don't know how you make it like he was sitting there twisting his mustache, making her look bad for jollies.
Yeah.
Like, I don't get it. I don't get it.
Yeah.
Yeah.
And that kind of brings me to another motion in limine I was excited about was the character evidence of Jed Wallace is not a party, and we are not going to bring his alleged prior smear campaigns into this case. Prior bad acts and outside bad acts not used to prove that they acted in conformity with those bad acts here. That's not allowed. Oh, and by the way, Jed Wallace, not even a party. So it has even further prejudicial, it's more substantially prejudicial than it is probative when we're talking about the Wayfarer parties, and it ends with us LLC. I was really excited to see that because I know the internet loves to be like, well, Rebel Wilson and Amanda Ghost and, you know, blah, blah, blah. And I'm like, that's not coming in. And people
Did you
get
like
real
how
mad at me when I say that.
Did you like how they name dropped Nathan's client list and mentioned Drake, who is Gottlieb's client?
I did. I like that one.
I was like,
missed
ooh, that hits home. That one, that's hard to fight. Like,
Yeah.
what are you gonna do, Gottlieb? Throw your other client on the bus?
Yeah. Which, by the
It was
way,
good.
he has an ethical obligation to not smear Blake, arguably, right? Because anything that you do in this case that could harm another case, you have the ethical obligation to stay consistent. So I think Gottlieb's backed into a corner on that one.
Well, between Jed and Melissa, and then they also, like, Wayfarer's worried about them talking about Friedman. Obviously, that's the intent, is to, like, let some stuff slip that these guys are also involved in another case that's highly sketchy. But I don't see any cognizable argument why that is even, at best, it's propensity evidence, which is out anyway.
Yeah. Yeah. So I love character evidence. I love the ins and outs of it. It's real fun. It's just a clean, good time. But I was really excited to see that because that's been a big court of public opinion talking point, is that these people are definitely doing this over here, which, by the way, those are still just allegations in that case that no fact finder has found, to my knowledge. So I was happy to see them say that. And similarly, the 7 other women, I'm glad we landed on a number, because we were between
at 9,
5 and 11, I think, for a while, just sort of nebulously throwing names in there. So I'm glad they put that in there as well. All of that, I think, you know, Jenny Slate, I think, is Blake's strongest argument. But at the end of the day, calling someone sexy doesn't rise to the level of harassment. So how can you use that evidence to say I felt it was a hostile work environment when it
I just
doesn't
don't
rise to that
see
level?
what her testimony could be relevant for. Like, if we're talking about whether Blake had a reasonable basis to make her complaint or whatever, what does Slate's testimony have to do with that? Like, it doesn't even matter if Slate thought she had a reasonable belief. It just doesn't. She's like, nothing about what she has to say is relevant to the retaliation claim.
I think
right?
what Blake says is, I watched Justin call other women derogatory names, and that made me have a reasonable faith belief that it was a hostile work environment. I think that's her argument. But again, I don't think it's a strong one, given how it's a throwaway comment that doesn't rise to the level it needs to under the
Whose
law.
dog is barking? Is
That's
it your
mine.
dog? Okay.
Sorry.
Okay.
Rosie would never. She has little
Right,
coyote
fuck you.
yips.
He's like, it's 5:30. That's about half an hour away from when you're supposed to feed me. And so I don't know why you're not getting ready to feed me, but
Yeah.
Understandable. I don't think Jenny Slate would help either. Like, I don't think that would help Lively. She's not like someone who has a ton of star power. She's not like super charming or likable. I don't understand how that would help her.
But I also just don't see what she's going to testify about. Like, Lively can say, Jenny told me this. Like, you don't really, and they probably wouldn't object to that, even though it's hearsay, right? Like, okay, so what? But like, what are you going to have her say? Like, yes, I did say that to Blake. Okay, so one sentence testimony. What else is she going to testify about in this case? Like, none of what she witnessed on a personal level relates to the retaliation claim, if that sticks.
Yeah, agreed.
People asking about PGA letter. I definitely think that's coming in. They're going to make hay of that. They should make hay of that because, again, it goes to one of the things that it goes to is the fact that this is what they were up against. Like, they have someone that was presenting this movie in a particular way, and they were worried about the narrative. They can say, put someone on the stand that says we just did not agree with her characterization of what happened on set. Example, all of the things that she say in her PGA letter, we don't agree with how she characterized it, and we were equally worried about how she was going to characterize things to the media around that time. So I think it goes to all of that.
It also, to me, goes to her reasonable faith belief that she was being harassed. You're going to tell me this person with all this power and all of this responsibility and all of this authority and the ability to hire and fire and the ability to help people get through PR complaints, all of a sudden now feels powerless. And that's a reasonable faith belief that she felt powerless and she felt harassed. That doesn't make sense.
Yeah, good point.
Okay. I'm looking up in the order because somebody asked a good question, which is what state's law covers the rider? Because it doesn't have choice of law language in it, right?
No, it is. I think Sarah and I were talking about it the other day, and I think she said the lawyers from California are mentioned on it. Yeah, both lawyers are California, and that's as close as we get. Because I was thinking that one of Blake's arguments to the motion for judgment on the pleadings is that she did have a reasonable faith belief that FIHA applies because the contract said California, and she thought the rider was governed by California.
Well, because they referenced the ALA, but the court found the ALA unenforceable. The ALA had a choice of law provision, but the question is, what without the ALA, what is the CR?
Both lawyers are California, and it's care of WME in Beverly Hills. Thanks, Sarah. You're my girl.
But it was about a movie that was being made in New York.
Right. I mean, I don't think it's a strong argument, but I think it's an argument that could be made.
Yeah, I'm just wondering, like, it's a really good point. Like, when you start instructing, I mean, maybe there's no functional difference between New York contract law and California contract law. But I wonder, because no one's made those arguments yet.
Yeah. I'm interested to see how she comes back. I think, of course, she's going to say this isn't timely to the MJOP, right? Which I would make that argument too. I don't know that I would counsel my client this far into this way, but
Yeah, but timeliness arguments are always kind of like, well, are you prejudiced?
Yeah. Yeah.
Right.
I mean, I've straight up had a court say, oh, we've gotten through motions for summary judgment and they want to reopen discovery. Yeah, we'll do that. So it's a tough one to make. It's a tough one to win. I have about 15, maybe 20 more minutes. Just
Okay.
Mom and I are going on a mother-daughter date.
Cute.
Yeah.
Aw, that's so nice.
Yeah.
Love that. I pulled out my printed order, guys. I was criticized for using only red tabs, by the way, which I'm offended by because I only had red tabs.
That's all you own.
All I own is red tab. I haven't used tabs since I don't know when. Maybe when I was litigating, but that's the only thing that I had.
Oh, I love a tab. I
Yeah.
get very excited about it.
But don't worry, I use color coded highlighting, so it made up for it.
That's acceptable.
Do you remember when you used to highlight issue, rule, analysis, conclusion, IRAC? Still nerding out.
I've been teaching IRAC this semester, and it is a fucking trip to be like,
Yeah.
remember you do this and this. Oh my god. Yeah.
So just to go back to this question of, I mean, the court is looking at consideration under California law, contract formation under California law for the CRA. So I do think that like maybe California law applies. I don't know how much of a difference that is with respect to like breach, but maybe that's where it would fall.
Yeah.
I don't know how much time they have for the pretrial conference, but between all of these and the Daubert motions, this is like 3 days worth of hearings.
Oh my God. Yeah.
Yeah.
So I don't know how that's all going to work.
I think he'll probably preliminarily rule, I'm not going to touch these. He'll probably say, I want to hear about this, 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 and this. And everything else we'll deal with at trial. That's what my guess is.
I would imagine he'd want to get into the expert stuff just because voir dire at trial is a kind of a nightmare, right? Because bringing the jury in and out is a whole thing. It takes 20, 30 minutes, maybe longer to make sure they're gone, to put them back in the jury room. I mean, it's a whole show, right? So I could see him wanting to deal with the experts before trial. And then maybe even limiting the scope of what they can testify to.
I mean, if I was Wayfarer, I would say, can't you deal with these dispositive motions first? Because if you grant either one of those, some of these things are going to be moot. Now, he may say, no, I'll do it whenever I want. But I mean, I think that's the best argument.
Lyman does what Lyman wants.
What do you think the briefing schedule on that is going to be? Do you think it's like the typical briefing schedule, or he's going to come out and say, I want to hear an opposition on this by a certain time?
I think they agreed to April 15th.
They agreed?
15th, 2 months after the trial. Yeah.
Like a week, I think.
They pushed it back to April 15th.
But that applies to the MJOP?
He said in that hearing that nobody could hear because there was that minute order, the one that was last week or 2 weeks ago or whatever. He said something about a deadline to respond to TAG's renewed summary judgment motion if it decided to make one. Now, you're right. He didn't anticipate the MJOP, but that would make the most sense.
Yeah.
I think what people probably are realizing that folks don't know is that, like, once you get this close to a trial, once you get within 6 weeks, like some cases are simple and you don't have to go through all of this, but like the case changes every day because people are getting fatigued. And I know nobody thinks that they're going to settle, but I guarantee you they are talking about it. Even if the conversations are one person keeps coming back and the other person keeps saying it's still a no, right? Like all of those things are happening.
The parties jointly asked for an extension to April 15th for the responses to pretrial filings. He said the responses were due April 10th to TAG's motion for summary judgment.
Okay.
That's my girl. She's always got my back.
Sarah's on it.
Sarah's on it
all the time. Yeah, settlement is always on the table. I just settled a case where the parties were so deeply entrenched that we thought mediation wasn't even worth it. And then one party shifted a position just a little bit and we were like, we could actually settle this now.
So it just takes somebody to be like, I am over this. What if I do this? And you're like, that is a settlement position we can mediate. So, and if there's a lingering threat, or if the judge does dismiss retaliation,
Oh yeah.
you
If the
know,
judge dismisses retaliation, I can't understand why Lively would want to go to trial on a contract dispute.
I think she asked for interlocutory appeal if
Yeah.
that happens. I think she says, we put a pause in this. I
Yeah.
appeal what you've done, and we come back and decide what to try based on the appellate court.
I mean, I think I've said this on another live, probably the last one, but I had a trial where when the plaintiff rested, it was very clear they were going to lose based off of what the judge said, even though it was not a jury trial. It was a judge. It was just the judge was the jury. And he made a very stern statement to the parties about how upset he was that we even brought him to trial on the case. And so it was clear how it was going to go. And then we settled right in the middle of trial, literally right in the middle of trial after the plaintiff rested. So it's very possible, because it's all about leverage. It's all about at what point do the parties see that they have an edge? And a lot of this stuff is posturing by both sides. You know, they're maybe they put Ryan Reynolds to signal like, we mean business. We're going to drag you guys, you know, at any point that we have, or Wayfarer's numerous motions in limine, same thing. Like they're going to act like they're, you know, ready to go to trial. But at the end of the day, every single day is an analysis of whether or not this is worth it for them to go through trial. And their lawyers, if they're doing a good job on both sides, should be telling their clients, this is what you have to lose if you go to trial. And I have to, I am obligated to tell you that. And if they're not doing that, they're not doing their job.
Yeah, and now, like, I think even the best possible day for them is not that great, because everybody knows that the sexual harassment is out. And so let's just say she has the best trial ever and she gets this verdict against them. I don't think that means that everyone's gonna be like, oh, she was right all along. I just don't think a win is as good of a high as a loss is a low, right? Like in terms of the risk benefit analysis, a loss is devastating.
Keep in mind too, there's the sequel. Yeah. And if this really was about the sequel, they could say, fine, have it. We'll give you the sequel. We make donations. You know, I loved the settlement proposal you came up with.
Yeah, I liked that.
Somebody email the teams, but, you know, and maybe they say, fine, you get the IP. But we want non-disparagement between, you know, all the parties, all the non-parties. We want non-disparagements between everyone. We want, you know, a gag order on talking about this. No documentary film gets made about this. You get the IP. You get to go off and make the sequel. Fine.
But it's also possible. I mean, somebody pointed out, I can't remember where, so sorry, I don't remember who to give credit for this. It wasn't me. But somebody pointed out that actually Amber Heard won trial. She won that case.
She won a counterclaim.
She won a counterclaim against his attorney.
But nobody remembers that.
Right. No.
Because he won against her as well. And so that's the narrative. And so it's possible that they don't care what the outcome of the case is, because ultimately this is a trial of reputation and they're hedging whether or not it's worth it to go through the trial anyways, because what is, and I'm not a PR expert, so I don't claim to be one, but that's the analysis that they're going through is like, does it even matter if she wins or not? Do they want to drag this through trial just to secure whatever PR win that they think they can secure? Which goes to why I think it's interesting that they're like, but we don't want her Instagram statements to come into evidence. It's like, no, you can't have your cake and eat it too, lady.
And that's why we tell our clients, do not be online while you are in trial. Do not be posting on Facebook about any of this. Your posts on Facebook are, look at how cute my dog is. Look at this pretty hike I went on. Look at this meal I had. And that is it. And for somebody as high profile as this, I would tell them none of that.
I think most of the people in this comment section would agree with me that if they went to trial and Blake somehow managed to eke out a win, that they purposely damaged her reputation, everyone would just immediately say, oh, we're going to blame the New York Times for that. That's the New York Times' fault because they screw. I don't think anybody is going to say, oh yeah, Wayfarer did something bad. I think that is gone.
Yeah.
I think the people who believe that are going to believe that no matter what, and everybody else isn't. And so I don't know like what it is she's going for, because she can't get back the idea that maybe she was the victim of this whole thing. That is gone.
And to be honest, and this is, again, Sarah, she's brilliant. This is more her thought than mine, but I've adopted it as my own because it's smart. Wayfarer's already had a huge win to go from they sexually harassed her to this is a celebrity feud, right? That shift in perspective already is a huge win for them. And maybe the best they'll ever get, you know, because there are always going to be people that believe that they did this.
Sure.
But the reframe, I think, was huge for them.
That's an excellent. Sarah's always so good at these things. That's an excellent point. It's just, it's not. Sometimes it takes a little while for it to settle into what it actually is. And like, yes, there's all these legal arguments about sexual harassment and all that. But you're right. Yeah. The stakes are so much lower now, which is why when she made that statement on Instagram about digital violence, we were like, why are you ratcheting up the language when what actually happened is the stakes just went down?
Yeah.
I don't know. I think people are also tired of it.
Yeah.
And digital violence is a choice when you've affected real people and real people felt silenced and real people were crying about, I don't know if Blake Lively and Ryan Reynolds have my personal information, my home address, my email addresses, my bank accounts. Like, you know, there were real people affected by that felt that was digital violence. So that was kind of whoever told her to make that statement, yeah, go ahead and hit post. I don't know if that was Sigrid. I don't know, but it was bad.
Yeah.
I think when you try to make yourself the spokesperson of an issue on purpose without just becoming the spokesperson on the issue, it doesn't work. Yeah. You know, she tried to make herself the spokesperson for women, and then she tried to make herself the spokesperson for sexual harassment. She's trying to make, like, you can't do that stuff intention. It has to happen organically because of, or it has to at least appear that way. And it all just feels so contrived. And I think that's why it doesn't feel earnest. Yeah. Like, you know what I mean? And so I think
Attorney Stara has a really good question. And also we love Attorney Stara. Go for
yes.
Well, and what is worse, the smear campaign or false sexual harassment claims? That's the position she left with. And that's smart, right? I was just talking about this with a family member who knows nothing about this and is like, oh, I really like Blake Lively. And I was like, here's what the evidence is showing us. And she was astounded. She was like, oh my God, that's disgusting. You know, and I'm like, here's where we are.
I think it's so fascinating to think about, like, are we finally reaching a place with Me Too and, you know, women telling their stories that we're kind of settling into how much evidence we need to decide whether someone's telling the truth or not? Like, I don't know if y'all have seen, but I've been seeing all these stories all day about these allegations that have been made against Eric Swalwell, who's running for governor in California.
I've met him actually. Oh,
yeah, they're going to keep in California. For sure. Yeah, and there's like there's 4 women now. And it's like my metrics for what I look for in order to determine, like, is it numbers? Is it what they say? Is it right? All of that. I think since 2020, I've started to develop like my own metrics for figuring out, like, what evidence do I need to see before I believe this stuff or not? Mm-hmm. And I think that Blake's case was always based on the fact that it wouldn't matter what the context was. We would just say, sure.
Yeah.
And I think that's why all the people who call all of us misogynists because we don't just believe her, it's like, if society changed to say we believe women, then the next thing that naturally happens is, what do we need to know before we don't?
Yeah.
And I don't know about y'all, but a lot of people have figured that out through this case.
Yeah.
Yeah. I mean,
Yeah,
it can't
somebody
just be
commented on my last video, like, "Oh my gosh, I can't believe a woman would say that this legal maneuver was brilliant." And I was like, "What do you
Oh, I
mean?
saw that.
How could you how could a why would a woman not be able to discern whether a legal argument is brilliant or not?" And like we cannot become this simplified in our thinking and blind ourselves to reality by aligning ourselves with these sort of false identities in a sense. Like, really, the question we should be asking each other is, why are we okay with dishonesty? Why are we not holding each other to a higher standard to be honest about in
Yeah.
all of our actions in everything that we do? Why do we praise dishonesty and sneaky behavior in our societies? That to me is a bigger concern and question.
And isn't the idea that we can only be victims and we can't be perpetrators in itself a form of misogyny? Isn't it saying that women are only this one thing within society, right? You can only be a victim, right? Or you can a mother Jezebel victim, right? Like those are your options, right? It just feels very simplified and takes out the complexity of the human condition. And to say you have to believe women despite massive amounts of evidence, what about the mothers that are abusive towards their children? I'm really sorry, I can't believe you, honey, because your mom's a woman.
Right.
You know, and it just, yes, we should believe women as sort of a mantra to check ourselves when we hear something and our gut reaction is, I don't believe her, right?
Of course.
But we are beyond gut reaction. We've seen a lot of discovery. We've seen a lot of disclosures, and
Yeah.
and it just doesn't look like the story she told us is at all true.
Well, I think Little Girl Attorney and I have both probably seen over the course of our collective careers doing employment law and dealing with discrimination claims, people make claims without any foundation all the time.
All the time.
Every day.
And they're not all necessarily malicious, right? A lot of it is like they misunderstand, or it's like, hey, I've gotten 5 written reprimands in a row. I need to put something on the record about, why this isn't my fault. Like, I'm sorry, but it happens all of the time. And it doesn't mean that everybody is evil incarnate. It just means that people will use whatever tools are available to them sometimes to try to deal with a situation that they find untenable. And there's no legal claim in the world where 100% of the people who claim it are all 100% right. It's just not how it works. And so I just find the idea that we're supposed to think of it that way. Like, it's easy to say that if you're not dealing with it every day. Like, Star just put a comment and is like, unfortunately, she knows that there are fake DV claims.
Yeah.
Unfortunately, that's just part of the world that we live in. Like, to Britt's point, that doesn't mean we don't believe anyone, but it also means we don't just assume that 100% of claims are absolutely positively true without evidence for it. Like,
Doing family law has really given me a sense of discernment too, because in family law, domestic violence takes away certain rights from the offender, right? So you don't have the presumption that you get to have legal decision making as far as where your kids go to school or their medical care. You don't get a presumption of equal parenting time, right? You have to overcome that. And so I have seen cases where mom comes in and says, I'm a victim of domestic violence. He beat me up. And when we start getting into the nitty gritty of it, it's like, there's no way that happened. This happened on this day. He's got receipts from hanging out with somebody else. I mean, I've had cases where it just wasn't true. And there is sometimes motive to make it up. And that doesn't make them bad. They're acting from a sense of a trapped badger is going to act out, right? Like they're,
And
people are
sometimes
complicated.
it has to do with, and Nag and I probably, it relates to our line of work a lot, is people's lack of ability to take accountability. Like, you got a bad performance review because we didn't think you did your job well. Like, that's it. And maybe you're right. maybe you were doing your job well, but at the end of the day, your manager didn't think you were doing your job well. And that's why you were given a write-up on your job. But a lot of times I see claims come out of that exchange because people don't want to accept that they're less than the stellar thing that they have in their mind. And to some extent, I see that play out here in this case as well. It comes from a lack of holding oneself accountable for their actions or what have you.
Or asserting rights you don't actually have. Right? I asserted a right that I'm allowed to work from home because I'm, whatever. And it's like, that's not actually a right. It's really unclear that that's actually a legal right. So you can't say that you asked for this right you don't actually have, and then we fired you for your bad performance, and now that's retaliation. But they're going to make the claim anyway, because to little girl attorney's point, people don't take accountability. That's not the world we live in. That would be emotionally healthy and crazy.
That would be nuts. But like, this is exactly the point of why Blake Lively wasn't subject to these kinds of claims, because she doesn't need them. Right. So if you're a regular employee and your performance is bad, and maybe it is because your boss is always touching you or something weird, you need to be able to make that claim so that you can overcome the fact this is affecting my job. I need to be able to tell someone, right? But if you're Blake Lively, you can just say like, I'm not coming back to work unless you sign this document. So,
yeah,
right. Like that's the whole point. And I was, in the podcast that I did last week, like I did it all on this. And the point I was just trying to drive home was like, the fact that she isn't covered is actually proof that the people who need to be covered are, right? Because so many people have been saying, well, if it can happen to her, it can happen to you. And it's like, actually what this just proved, what the order proved, is that that is not true.
Yeah.
Because all of the people who are housekeeping and secretaries and low-level people are covered by these laws in a way she's not, because they need it and she doesn't. And that's why the technicality stuff really bothers me, because it's like, yeah, if the power dynamic in the workplace is a technicality to you, then sure.
I dare any attorney, or because I've seen a couple of attorneys now say it's a technicality. Next time you win on summary judgment, go ahead and frame that as a technicality.
Right.
Hey, that was a big win. Nah, it was a technicality. No, that was a dispositive motion, actually. So, yeah, it's a frustrating line of argument. And, I think we touched on this last time, and I am going to go here in a minute, but there is discussion to be had. I don't think the answer is we broaden the laws to cover independent contractors. I think what we do is we narrow the ability to have employees that are independent contractors, right? And I think there's a conversation to be had of where we're landing on all that and how we're actually protecting employees. But to your point, there are mechanisms that do protect independent contractors, and they are protected.
Yeah.
So
that's true. You go on your date with your mom.
Date time with mom. Thank you, everybody. Sorry, I have to hop off early. I love spending time with you both. Everybody give these women their flowers, like and subscribe. I think that's what we're supposed to say.
Are we supposed to? I've never said that.
I never
smash that like button. You guys.
I can't do the smash. I can't.
Smash that like button.
I'm sorry, I was being sarcastic, and now I've breached a contract.
You violated the contract.
Well, I've probably got 20 more minutes left of me. How about you?
Yeah. I have some help feeding the pup, so
okay, good.
Bye, everyone.
It's gonna be fine.
All right, bye.
Bye, Brid. Yeah, I mean,
sorry.
Ahead.
Sorry.
Yeah, no, go ahead.
This is this other thing that, like, I just want people to know. I said it somewhere that, like, because some people, including that moron with the X, his profile is X something, did you know that, there's 12 million independent contractors who aren't covered? And I'm like, did you know that 50% of the American workforce works for small businesses, which means that they aren't covered either?
Yeah.
Like, federal laws don't cover every employee in the country. They only cover employees who work for employers that have a certain number of employees there, 50. And
Also, you can move to a state that covers it, like California.
Also, right. But it's like, it's been unfair since go. It didn't become unfair because it happened to Blake. Give me a break.
Yeah, it's been law for a very long time, longer than all of us have been alive. And that's why I find it so infuriating to call it a technicality, because everybody knew going into this what that law was and made choices about which claims to bring. And like, that's how law works. When you win on a legal argument, you win on the law. I mean, I don't even know why we're having this conversation. Like, it feels so silly to me. But to the question about, like, oh, if this can happen to a big movie star, what protections do I have? Well, this is the whole point of the freedom to move around and get whatever kind of work you want in this country. And yes, there is a discussion to be had about whether or not we need to address the fact that we are moving into a bigger gig economy. And to some extent, California has done that, which I was astounded when the order went through the ABC test and the Dynamics case. And because California is trying to grapple with the fact that there is a growing gig economy and really what makes a gig worker versus an employee, and really trying to parse that out. And I'm not sure that it's got it perfectly down, but they're trying. And even still, they're allowing the laws in California to apply to contractors. So contractors are protected under state law for these. And so there are places where these protections exist. It just so happened that Lively didn't fall under any of the protections. And it wasn't necessarily her decision to bring the claims that she did in the way she did. Her lawyers had a big hand in that, and they thought that this was the best way to do it for whatever reason. I do not know, but from the beginning, this was an issue, and they definitely knew that it was an issue when they brought it up, but they tried and they lost.
Of course they did. Just my 1 sentence soapbox is that if we were not living in a situation where your healthcare coverage was tied to your employment, people would that would make a change for people's ability to move around jobs more than any employment law ever would. Because I'm sure you have the same thing as an employment lawyer when you're talking to people and it's like, well, you're going to get fired. Why don't you just leave? Like, they're going to fire you. They're going to fire you. And the answer most of the time is, I can't afford to lose the coverage. Yeah. So there's so many things that go into the analysis of how people decide to move jobs, but none of it has anything to do with Blake Lively.
Yeah, no, definitely not. And it's a separate conversation that should be had, but it's incorrect to couch this as a loss or somehow creating precedent or somehow undermining the rights of people. No, this is well-established law. It's always been the case. And nothing about the judge's decision changes the reality of what would have existed without this case. It would have been ruled exactly the same way in another federal court on another day with other parties, with the same facts. And that's just the truth.
Also, this is just, I guess, one of my problems with the internet. I have no respect for someone who follows a case for over a year, reads a 152-page order, and never once is like, oh, that's kind of a good point. Like, you can, I have recognized that some of Lively's motions to limit, I'm like, okay, I see why she's arguing. I think I might agree with that. Right. But like, how are you credible when you're like, I was taught, God love my parents, they have their issues, but I was taught that not being open to new ideas or changing your mind is what dumb people do. Like, smart people are always open to changing their mind. And like, yeah, we all get dug in on our, like, I've decided how I feel about this. Right. But like, imagine reading the 152 pages and being like, nope, That is not someone trying to give you real commentary. That is somebody trying to send you a message that they very much want you to have. It's propaganda, is what it is.
Yeah. 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 The thing that I've definitely learned in this case is that people are actually, people meaning everyone here watching, are way more discerning than the people with money give them credit for. And I think in many ways, this case has lifted that veil from the power that people with money have. Because when you have a public docket where people can read everything for themselves, they can come to their own conclusions. They don't need mainstream to tell them or some other higher, bigger power to tell them how to think. They can think for themselves. And so, to the extent that this case is now about, can people think for themselves or did you make them think this? Like, it's an interesting question. And I think a lot of people are invested in this because they don't want to believe that they're completely manipulated by it. The irony, I think, is that mainstream media is still trying to manipulate the narrative in one sense or the other. And so it's just this really weird dynamic, this kind of like, we're trying to tell you that you're being manipulated because we know we manipulate you.
Right. It's true. It's true.
Like, it's wild to me almost. It's like, how can you be more obvious that this is what you're doing? You know?
I agree with you. I have been so pleasantly surprised by how many people are like willing to sit and listen and think about it and come to their like it, certainly like depending on the conversation, I'm sure you're going to get a different crowd. But, somebody asked me earlier today, like, we were talking about the Van Zandt stuff. And it was like, I think the reason they wanted in is part of the reason is because they saw how much everybody following the case hated it. And somebody said, do you really think they pay attention to what we do? And I was like, if you were the attorneys working on this case, you don't need to do a mock jury. Y'all are the mock jury.
Mm-hmm.
Like, they're able to watch what you guys say and how you guys react in real time to the information that's coming out in the case. And that is invaluable to them.
Yeah. Can you imagine? None of my cases had this.
Oh my God.
To know what a jury might think, like, it's incredible.
Oh my God. And it's they can obviously put it into strategy, but to the very good point that you just made, at least everyone who follows you and everyone who follows me will never believe anything on TMZ or people.com ever again.
Yeah.
Right. So it's like, you start to chip away at where people will get their information from. And I agree. That's why I don't understand some of these PR strategies. I think they've gotten a little bit less lately from the Lively side, but it's like, why are you bothering? We know what it is. Everybody, Katie and KC, who is a very smart person, but is a dietitian who's just very discerning and intelligent, can understand what everything is. Like, they do sometimes talk as if people can't figure this out. And I don't think they get it. I really don't.
Yeah. No, I find it offensive, actually, because like there's a smaller gap, and I think the whole law field was somewhat designed to create that gap between lawyers and the public, and I think that's where you and I come in and Britt come in to try and break that gap, because you don't need to couch things in legalese to understand the concepts. Everybody can understand the concepts, and so I don't even know where I'm going with this, but I think that people can see it. If you just break it down, people can see it. It's not rocket science, right? Like, it's very, very simple. And I've been so impressed by people remembering things and details of this case that I don't even remember. And the analysis, especially like just reading some of the analysis on Reddit, I'm like, yeah, you broke that report down way better than I could have.
Yeah.
And part of that is because people come from different modalities, different backgrounds, different skills that bring a different lens to the table. And at the end of the day, that's the jury. at the end of the day, you're going to have an engineer, you're going to have a store clerk, you're going to have a hairstylist, you're going to have a content creator, you're going to have all these different people with different perspectives on things, and you're going to have to speak to them. And if you don't know how to speak to them, or you think you're better than them somehow, then that you're not going to win them over. And so, to your point, I would, if I was on either side, I would hire a full-time associate to just read social media comments
100%.
all day long.
100%. And honestly, like, I think that the only way to have like truly good celebrity PR anymore is to like have an authentic moment, which, you know, sometimes people try to contrive authentic moments, but like what happened with the heated rivalry guys, like nobody could have contrived that, because it happened, like they are who they are, and that just happened to work in exactly that mix at exactly the right time. And that's why I think people were like, oh, you know, this is something that I'm drawn to. But I think we can feel out the fake stuff so much easier than we used to. That I think that it's practically impossible. I think somebody said this earlier. Was it you or somebody else in a comment said something like, you used to be able to buy good press, right? You used to be able to say, like, you got enough articles in enough places or the right paparazzi pictures or whatever, you could buy good PR, and you kind of can't do that anymore.
They're trying. They're trying, though.
They're trying. But I think if I were Lively, I am not Leslie Sloan, thank God. But if I were her, I would be saying, girl, do you know how many photos they're going to take a photo of you every day when you go in and every day when you come out, and God forbid you have a bad look on, like, this shit will never go away.
Yeah.
Just, you know, I mean, remember what happened with like the one photo they got of her walking out of the
one
mediation?
photo. Yeah.
People
the
ate out on that for a
analysis that
week.
was done. Oh, this pink is connected to that, to this, is like, okay.
Oh my God. Yeah. Remember how there was like, this was early on, maybe like 6 months in. Remember how there was some article where she said like, that Blake Lively was thinking about going into law, just like Kim Kardashian, because she was having such a good time, and we were all rolling our eyes. I guess that's over.
Yeah. I crashed out on that one.
Poor Kimmy. She didn't make it. That's okay.
Yeah, she did it, huh? Yeah.
Okay. I mean, I think we have to just keep reading this stuff, but a lot of it we can't really tell. I want the responses, right?
Yeah. People are saying that there's something that have been filed. Obviously, we've been on this live, so haven't looked, but we'll keep an eye on things as they come in. But yeah, I would be surprised if they're filing stuff today, because I think their deadline was yesterday, but who knows? But yeah, we'll see how they respond. And I'm most curious about what's going to happen with this MJOP, because that's the game changer. If the judge grants it or entertains it, then the case goes to a contract dispute. And then really Lively's side needs to determine whether or not they want to go through with this case at trial. Is it worth all the money? Hundreds of millions of dollars. Is it worth it? I mean, I guess they've already spent a lot of it, but you know, another million plus.
But like, is it worth it to go to trial on a claim where the best case scenario is that somebody violated a contract that a lot of people don't even think should have been signed? Like, is that
exactly
breach of contract? You know, LGA and I were talking about this last night, and I just want to say this publicly, and I think you'll agree with me. If everyone could just like pour one out or send a good vibe for all of the baby lawyers, associates, and paralegals who probably have already spent and are continuing to spend practically 24 hours a day
on both sides,
all of the firms on both sides of this case, writing this stuff so that it can be done on time. Like, yes, they're getting their billable hours, and yes, that's part of the deal. And we have both been there, right, where you're doing that, and there's this weird sense of camaraderie. But there are a lot of people whose names you don't know
And
who
we'll
are
never
working
know.
there, and we'll never know, who are sleeping in their office, not seeing their families, working their ass off, living on iced coffee so that all this shit can get done. Mike Gottlieb does not sit down at a computer and type out a memorandum of law. Someone else
No.
researches it and someone else drafts it and he finalizes it.
And he writes
And
his name on it.
and he writes his name. Same thing on the other side, right?
Mhm.
So just
Yeah.
when you're thinking about all this, just think about those people, because those are the real heroes. And then it's like, oh, you know, somebody's going to have to go find the cases that go against the MJOP. And like, what if the cases aren't good enough? And then they get somebody screaming at them. There's got to be a better case than this. And like,
Yeah. No, I
just feel
mean,
for those
they're
people.
for sure they didn't sleep on Thursday night. I don't think any lawyer on this case, any of the, how many are there now? 20 on each side. I don't think
Yeah.
anybody slept to get this stuff out there. This is a lot of work. The stuff to get to get these filings out is a lot of work. And I think everyone that we know their names was probably awake until it got filed. And they were filing late into California, it sounds like. But to your point, like when you're an associate, you're just like, all of a sudden someone points to you and is like, go research this and go write something. And you're like, about like, what are the issues in this case?
So I don't know if Mag realizes these baby lawyers are being made to watch this. Hi, baby lawyers.
Hi, baby lawyers.
If you're doing what we think you should. I had a case one time where I used to work for this guy, and I'm still friends with him, but he's such an asshole. And he wanted a case, and he was like, would put the baby lawyers through it. And it would be like, I need a case that says this. And then you'd go and you'd be like, well, I can't find one that says this, but this. And he was famous for this. He would throw it down and he would go, what? And he would put his hand on the phone. What do you want me to do? You want me to call the client and tell them we're going to lose because you couldn't find a case? I mean,
oh my God.
It's like, dude. And if the first couple of times you go to the bathroom and cry, and then like the fourth time you're like, fuck you, Rob. Like I can't, pull a case out of my ass. But like, that's what a lot of these young people are dealing with. So if any of them are watching, we know. We're sorry.
We know. We're sorry you have to deal with that, but you will be a better lawyer for it, believe it or not.
My husband just came and he's like, are you talking about Rob? I'm like, yeah. You work with him too.
That's hilarious.
Yeah, we're going to write a memorandum of law on that. And by we, I mean you.
I had a partner I worked for once that was like, he'd be like, there's this case that says this thing. Go find it. I would go for like 8 hours and I'd be like, I can't find it. It doesn't exist. And I'd come back and he'd be like, why did you spend 8 hours researching that thing that I told you exists? I'm like, because it doesn't exist. And I'm sorry. And he's like, no, it exists. So I go spend another 4 hours. He's like, I'm going to have to write off all of that time. So my like 10 hours of research gets whittled down to maybe 2. And he's like, oh, maybe I just thought that case existed. It's like,
I know there's a case, but they love to do that. I know there's a case.
Yeah.
And it's like, is there though? Well, at least they're going to make all their billable hours, and some of them will
maybe
partner.
Leave the big law firms. There's my bias.
I know. Well, like having us both worked at large law firms, like for people who stay there for this amount of time, like people like Ezra Hudson and people like Gottlieb, to stay at a large firm that amount of time, like they have given up
everything.
They've given up so much of their life. That is a 90-hour-a-week minimum job. Minimum. And there is no, I guess I'm going to go home now at 6 p.m. Like those people work. And for some of them, it's worth it for the money or the ego or whatever it is. But a lot of people start at those firms and not a lot of people finish at them because it burns you out.
Yeah.
And you look in the mirror and you're like, is this my life? Is this what I'm doing?
Yep. And here we are. Well, it was fun talking to you as always. And I'm glad that we could make this work. We will probably do another live soon, given how much is going on in this case. But we'll keep reading and we'll keep trying to answer questions. So thanks to everyone for joining us.
Yeah, and if you have questions that we didn't answer and you really want them answered, put them on in the comments when we put this as a post, and I think we'll probably circle back and try to answer what we can. But we're right here with y'all. We're living it with you.
Yay! All right, bye
Have a good
everyone.
Saturday. You get to have a night. It's 9:22 where I am.
Oh,
so.
it's bedtime almost for you.
Yeah, pretty much. Pretty much. But you go have an
gonna go eat
enjoyable
dinner.
night. Okay.
Thank you.
Bye.
Bye.
Bye.